Do I have to share my inheritance with my spouse? Maybe one of your parents has passed away, you've received a little bit of an inheritance, and you're not sure, do you have to put it in your joint banking account? Do you have to share it with your spouse by law? And the first place to look is, frankly, your local family law. And you want to talk to a local family attorney to find out what the state of the law is on inheritances in your state. Now, I'm not saying you're going to get a divorce. However, in the case of a divorce, we look at that law to find out whether an inheritance is treated as separate property, which it normally will be, or whether it's considered joint property. And you should know that if you take that inheritance and just put it in your joint checking account with your spouse and spend some money here and there, and then eventually transfer some money out to a separate savings account or even your joint savings account, at that point, you've essentially taken that inheritance and made it marital money. But if you take that inheritance and put it in a separate account, only in your name, that your spouse doesn't have any access to and frankly doesn't even know about, then if you ended up in a divorce, you wouldn't be looking at a marital property claim on that inheritance. It would be treated as separate property. So legally, you do not have to share your inheritance with your spouse, but I'm not telling you you don't have to do that. That's up to you and your relationship with your spouse. But you should know there's options, and if you have more questions, speak to a local family lawyer about the best way to address that inheritance coming to you.